Hello everyone and welcome back to channel. Today we are gonna study the 11th subchapter of Indian Contract Act, and that is termination by novation. So this is a very specific and powerful way to end a contract. So the foundation for this is section 62 of the Indian Contract Act. This section says that if the parties to a contract agree to substitute a new contract for the old one, or they decide to rescind or alter the original contract, then the original agreement doesn't need to be performed. So think of it like this: a new agreement extinguishes the old one. This isn't just a verbal agreement, it requires a genuine meeting of the minds. All parties must agree to the change. So let's use a simple example for novation. So let's say there are three people, Ram, Shyam and Kiran. So Ram owes Shyam some money. All three parties, that is Ram, Shyam and Kiran, agree that Kiran will now owe money to Shyam instead of Ram. The old debt is extinguished and a new debt is created between Kiran and Shyam. The original contract is terminated by novation. The next one is voidable contracts and compensation. So, according to section 64, if you have the option to void a contract, their promise, and the party rescinding a voidable contract must restore any benefit that received under it to the person from whom it was received. Because you were misled and you chose to rescind it, you are no longer bound by your promise. But there's a catch. You have to restore any benefit you received under that contract to the person from whom you received it. It's about fairness. And here is a very important point under section 75. If you rightfully rescind a contract because the other party failed to perform their part, you are entitled to compensation for any damages you have suffered. For example, if a waiter agrees to work for a hotel but then willfully fails to show up, the hotel manager can rescind the contract and sue the waiter for any financial loss caused by his absence. So, termination by novation, rescission, and alteration is a powerful tool in contract law. It allows parties to change or end its agreements. But remember, the principle of fairness and compensation is always a key factor. Okay, now the next subchapter or the 12th subchapter is tender procedure of government contract. So the first one is, what is a tender or bid? A tender is an invitation to an offer that invites bids from various parties. These bids becomes a contract when accepted, binding both parties equally, and they are typically used for specific work or supply of goods within a set time frame. Now let's see tender document. This document outlines the work or the goods to be carried out, including specifications, a time limit for completion and other terms. Bids are submitted by individuals, firms or organizations and are evaluated against the tender specifications. Now let's go to the next topic, that is General Financial Rules 2017. So this is a compilation of rules and orders from the Department of Expenditure, Ministry of Finance, Government of India. So it guides all government departments and bodies in matters involving public finance, including procurement and contract management. Now, Rule 144 of the General Financial Rules lays down the fundamental principles of public buying. So, Rule 144 deals with fundamental principles of public buying. The procedure must be fair, efficient and transparent to ensure economy and healthy competition. The next topic is key principles and procedures for public procurement, and that is Rule 144. So first one is subject matter description. It must be clear, objective and functional description. including measurable and specific technical and performance characters. Second one is trademarks. The specifications should not indicate a requirement for a public brand name or trademark. The third one is technical specification. So, it should be based on the national or international standards. And the fourth one is quantity control, and it should be taken to avoid purchasing quantities in excess of the requirement to minimum inventory carrying cost. Fifth one is fair process. That means it must offer invited through a fair, transparent and reasonable procedure. Sixth one is offer evaluation. The procuring authority must be satisfied that the selected offer meets the requirements in all aspects. Seventh one is documentation. A record of decisions and the considerations for them must be maintained at each stage of the procurement cycle. Eighth one is annual procurement plan. All ministries and departments must prepare an annual procurement plan and publish it on their websites. The last one is competence to purchase, and that is Rule 145. So, this rule provides or specifies that an authority competent to incur expenditure may sanction the purchase of goods in line with the delegation of financial powers rules. The next subchapter, or the last chapter in Contract Act, is Special Contract, Indemnity and Guarantee, Bailment and Pledge and Laws of Agency. So now let's study what are special contracts. So special contracts are particular types of contracts recognized under the Indian Contract Act 1872 with special rules. So there comes indemnity and guarantee, bailment and pledge and agency. So first one is contract of indemnity, and it comes under section 124. A contract by which one party promises to save another from loss caused by the conduct of the promiser himself or by the conduct of any other person. So the parties involved is the indemnifier and the indemnified or the indemnity holder. So indemnified is also known as the indemnity holder. So let's see the essentials or features. So there should be a promise to compensate the loss, and loss may be caused by the promiser or a third party, and it must be expressed or implied. Now let's study the rights and duties in indemnity. So the rights of the indemnified or indemnity holder is to recover the damages for the losses incurred under the indemnity contract and to recover cost expenses reasonably incurred in connection with the loss. And the duties will be as per the circumstances. The next one is contract of guarantee, and a contract to perform the promise or discharge the liability of a third person in case of his default is known as contract of guarantee. So if one person in case makes a default to pay, then this comes into existence. So the parties involved are surety, that means the guarantor, principal debtor and creditor. Now let's study the kinds of guarantee. There are two types of guarantee: specific or simple guarantee and continuing guarantee. So specific or simple guarantee covers a single transaction, whereas continuing guarantee covers a series of transactions. So the features are the agreement is among three parties, and the liability of surety is secondary and it depends on the default of the principal debtor, and it must be in knowledge of debtor. So now let's study the distinctions between indemnity and guarantee. So in case of indemnity, the number of parties is 2, and in case of guarantee, the number of parties involved are 3. Primary liability is of the indemnifier in case of indemnity, and in case of guarantee it is that of the principal debtor. So, in case of indemnity, loss event or cause itself triggers the liability, and in case of guarantee, only on default or failure by principal debtor. Okay, the next topic is bailment, and it means the delivery of goods by one person to another for some purpose, and that too upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. So there are two parties involved in bailment, and that is bailer and bailee. Bailer is the person who delivers the goods, and the bailee is who receives it. So the essentials or features are delivery of goods, that is possession, and purpose for which goods are bailed, and return of goods or disposal as per bailer's directions. Now let's see the rights and duties in bailment. Here there are rights for bailer as well as bailee. First, let's see the rights of the bailer. He can claim damages if bailee fails to take responsible care, and right to terminate contract if bailee uses goods beyond permitted use claim, and can also claim return of goods after purpose fulfilled or period expires. The next one is rights of bailee. He can reimburse as well as also he has a right on defect goods. The next topic is pledge, and that comes under section 172. A bailment of goods as security for payment of a debt or performance of a promise is known as pledge. So this pledge is a security. So the parties involved is pawner and pawnee. And pawner is who gives the goods, and pawnee is one who receives as security. So the subject matter is movable goods, delivery of possession, and special property in pawnee, etc. So now let's study the rights of pawnee and pawner. So first one is the rights of pawner: to retain the goods until payment, to use or take care, to resale, and to recover unnecessary expenses. Also with that of the pawnee, to take care and not to mix the goods, and also return the goods. The next topic is loss of agency. So it comes under section 182. A person employed to do any act for another or to represent another in dealings with third persons, the person for whom such act is done or whom he is so represented is called the principal. So this is all about the principal and agent relationship. So now let's study the creation or modes of agency. So first one is express agency, that means by words, that is it must be oral or written, and it comes under section 186 and 187. Second type of mode of agency is implied agency, that means it is inferred by conduct or custom. Third one is agency by estoppel or holding out, that means principal leads third party to believe someone is agent. And the fourth one is agency by necessity, and that is for emergency purposes. And the last one is rectification, and that comes under section 196, and it should be done without authority but must be later approved. The last topic is about authority, rights and duties of agent. So the authority is the actual authority and apparent authority, and the rights of agent are remuneration or commission, indemnity from principal for acts done in good faith within scope, and the duties of agents are he should obey to the instructions of principal and act with good care and skill, and he should not deal on his own account in conflict. And the termination of agency, there are two types, by agreement and by operation of law. And that's all with the chapters Indian Contract Act 1872. Up next, we will be coming with a new chapter. Until then, keep learning, keep growing. Thank you.